Recording in progress.
I fixed it.
Okay.
You were unmuted. It's fixed now.
All right.
You're good to go.
Thank you. This is City of Lansing versus JAJ Property LLC. Counsel, your appearance for the record.
Matt Staples on behalf of the City of Lansing.
Good afternoon, Your Honor. Edward Zing on behalf of JJ Properties. I realize I cut off Mr. Boot. I do apologize. If I can introduce Mr. Joe Boot from the City of Lansing, Your Honor.
He needs no introduction, but
I
for the
thought
record,
so.
that's good. All right, welcome, counsel.
Thank you.
All right, so for the record, I know a lot of you are here from the encampment and watching. We met at 1 o'clock. I met with council, and it is clear to me that they have been spending their time putting together an agreement, working out some issues that need to be resolved. This court has a hearing starting on Monday in regard to some of the allegations that were made, the responsibilities, who did what, who's gonna pay for what, all of that. And it is my understanding, and from reading a draft proposal, that council is about 98% in terms of their agreement. They have to work out some minor bugs, but we are going to have an agreement Wednesday at 1 o'clock that addresses all of the issues and housing. Correct?
That's correct, Your Honor.
Your Honor, that's an accurate statement.
Anything else we need to have for the record?
I don't believe so, Your Honor.
No, Your Honor. Thank you for your time.
Should there not be an agreement, we will use the rest of the week for that hearing that should have started Monday. But I have every confidence after reading the draft proposal that you all have put a lot of thought and time into it and are addressing the needs of the human beings who are at risk.
Yes, Your Honor.
Thank you, Your Honor.
Thank you. I'll see you next Wednesday at 1, and we'll sign the agreement and we'll publicize it at that time.
Thank you, Your Honor.
Thank you.
Wrong thing. We're good, I asked the wrong one, unmute.
All right, this is docket 90-60519 FH and 94-67188 FH. People of the state of Michigan versus Eric Sablovda. I'm not sure how to say your name, sir. I'm sorry.
Yes, Your Honor. Good afternoon. Eric Sepulveda.
Okay, thank you. On behalf of the people, your appearance?
Good afternoon, Your Honor. Natalie May come on behalf of the people.
All right. Court is in receipt of the required documents, sir, and it looks like the Attorney General, I don't know if you've received a copy, is objecting, my understanding is the people are objecting to the set aside because you have simply too many convictions, so it doesn't comport with the law. Now, the law may change, and at that time, you certainly could refile. I reviewed it, and it looks like the convictions that were on August 29th, 1990, there are two of those. Those could be deemed as one, but the rest of them, you're only allowed to have three, and you have many more. So I don't know how I can grant this.
Yes, Your Honor. Could I guess, offer an explanation of how I view this?
Sure, you can offer the explanation.
Okay.
It has to
So,
be based on the law, though.
right. Okay. So I appreciate that you could see the two felonies that are in 1990, and you have considered that as one. I guess that was one of the things that I wanted to address the court with. I think there's misclassification here on the felony that was on 12/12/89, which was the first felony, which was under a youthful. I believe I'm not sure of the term that he used back then, but youthful program, something to that effect, where I had a clean record prior to that. It ended up being a felony count initially, and ended up being at the end it was an attempted misdemeanor. So
Okay.
I believe that right there, and it's been addressed with Lake Odessa police, or with the Lake Odessa Circuit Court. I do have some correspondence from them. So with
So
that,
I'm sorry, sir, stop a minute. Which count was that? Is that the attempted weapon carrying unlawful?
no, that's the one that was dated in 1988, which is a felony assault, excluding sexual, in Lake Odessa.
I don't even have the 1988. If you received HIDA, it's probably not even on here.
Oh,
And
I see.
I believe he's talking about the conviction from, the date of the conviction is 12/12/89.
Oh, I got it. Okay, so that one.
Yes.
But it counts
Okay,
as-
so I see that. Okay. So that would be, it says attempt,
But it counts as a felony, because the
But
maximum penalty is over a year.
counts as a felony, and a felony is anything over a year, sir.
What do you mean? Well, I didn't do over a year. I did, I believe 90. They ended up giving me 90 days for that. Is that what you mean?
It's not what you did, it's how the statute is charged.
Okay, so just to I guess just to clarify and understand this, from what my understanding is, like I said, I've reached out to Lake Odessa. Not sure how it counts still as a felony, because it ended up being finally it ended up being an attempted misdemeanor. That's what it was assessed at. And that's what would hold me back as far as like the 3 felonies requirement.
Okay, so
I could
you may
provide.
have up to 3 Michigan felony convictions and potentially an unlimited number of misdemeanor convictions. However, sir, there is an issue, and maybe you can shed some light on this.
Yes.
The Michigan State Police report, Federal Response Section, says that there's a warrant that's issued for you by the 59th District Court in Granville, Michigan from 2025. What is the status of that?
Are you referring to, there's a current warrant right now? Pending warrant?
Yes, in Granville, you need to go to Granville and clean this up. And then you might want to talk to an attorney who might be able to help you clean this up, so it's 3 felonies. But apparently there's some kind of warrant for you.
Oh, well, yeah, I wasn't aware of that. What year would that be for? Is that a current warrant? I'm not even sure what this charge is.
Yes, sir, that's a current one. It's out of Granville, Michigan. It's the 59 District Court. So I can't even proceed when there's a warrant. So what I suggest you do is contact them, turn yourself in, figure it out, get a lawyer, have a
Yes.
lawyer review all these charges. If you can get it down to 3, you can re-petition me, but you can't, you have to have a clean record for a certain amount of time. So get this cleaned up. Maybe they'll dismiss it. I don't know. It could be for parking tickets. I have no idea what it's for.
Yeah, I don't
All
have
I know is there is a warrant. You need to clean that up. And then you need to look at these counts and get it down to 3 felonies, because otherwise, as much as I want to help you, sir, I can't. I have to follow the law, and so do you, sir.
Yes, I understand, Your Honor, and I appreciate you explaining that to me. I was unaware of any warrant. I'm not, it's questionable right now what that is, but I will definitely follow your instructions and follow up with Granville. And then I guess revisit this. Do I need to refile this whole thing again?
You'll have to refile because they're gonna have to take a look at this, and I suspect whatever attorney you meet, if they're going to clean up something, they've got to clean up whatever it is in your history, so that when the state police and the attorney general review this, they're only seeing 3 felonies or less.
Right.
Okay. Understanding the 2, they're the same dates, it counts as 1, but even then you still have 4. So you've got to clean this up, and I cannot have you, if you were here in front of me, you're lucky you're on Zoom, because if you were here, I am obligated to have you arrested because there's a warrant that I'm aware of. So you got to clean that up. You might want to call them. I don't know if it's parking tickets. I don't know what it is. Okay. It's in district court. So.
Okay.
It's 59th District Court in Granville.
59th.
So
Okay.
59th District Court in Granville, Michigan. So you probably want to get a lawyer, and if you can't afford one, you get a court appointed. They'll certainly appoint you one and get all this cleaned up.
Okay.
And then you can re-petition me. I have to deny at this point because I can't follow the law. So even if I granted it, sir, they're gonna toss it back as quick as I give it to you. So I wish I could give it to you. I love doing these for people. I do a lot of them. I just have to comply with the law. So please re-petition me, but you gotta clean it up, okay?
Yes, Your Honor. Thank you very much for your time.
Thank you, thank you. This is denied for now, but without prejudice. Thank you. That's all for this record. Next matter.
Not till 2,
What is it?
the MSD.
Well, if everybody's here, we could go ahead and have a schedule.
Let me see one gentleman right there. We can
So
certainly,
is everybody here on the Dawson Brody versus Mid-Michigan Lansing?
Defense counsel is, I don't think I've seen finance counsel yet.
Okay. Well, I'm ready when you are.
All right. Start out in the hall, right out there. I was trying to look for you.
Thanks for filling in for Nancy.
Sure, she's my buddy, I'll help her out. Hope she had a safe trip home and all this winter mess. Said, I hope she got home safe and all this winter mess.
She just texted, she's got a doctor appointment in the morning. And something at the end of the day, so I don't know if she's just going like very first thing, very last thing, I really don't know.
they're still in the hole.
But they're here,
Huh?
they're here then?
No, no, not for the next
Oh.
hearing.
Oh,
The prior hearing.
I see.
I need to mute it.
That's all the criminal for today, right?
Yes,
Mhm.
see,
please, add some more it from there, I just didn't ask the,
Yeah, you have to ask the court room to unmute and then,
oh, got it.
then hit it.
All right. This is docket 24585 and Karina Dawson Brody as next friend for Dream Dawson, a minor, and Karina Dawson Brody versus Mid-Michigan Lansing 3-Pack LLC and Superior Management Systems LLC. Counsel, your appearance for the record.
David Nelson, representing the defendants.
Yes, and good afternoon, Your Honor. Stephen Lovell appearing on behalf of the plaintiffs, and thank you for accommodating me via Zoom this afternoon.
All right, as long as you're feeling well enough to proceed, we'll proceed.
Yep, that's
And
fine, Your
counsel-
Honor.
Thank you. And counsel, you don't have any objection to him appearing by Zoom, is that correct?
Correct.
All right, thank you. And this is defendant's motion for summary disposition pursuant to 2.116C10. Counsel, you may proceed at the podium, please.
Thank you, Your Honor. This case concerns a premises liability matter relating to some bats at defendant's property. There's an alleged bite that occurred to Karina Dawson in sometime in September 2021, although no date has really been established as to when that occurred. The basis for the motion was threefold. One is as to the plaintiff's status essentially at the property. It was clear in the deposition testimony that the plaintiff was not she was essentially a resident at two different apartments from time to time with the defendants. She would spend her time between, I think it was her aunt, as well as her mother, I believe, at various points in time. She was living at these apartments. She was not the typical social guest that you would invite a friend to come over and stay. She was actually residing at this apartment and was living there. And it was intended allegedly to be temporary until she could get a place of her own. But she was living at this apartment. She was not on the lease of the apartment, so she was not. The owner did not have her there with permission. She was not listed on the lease. So this court has held that when someone is at a property without the consent of the owner, the person is a trespasser, and they are subject to the lowest level of status, not the invitee status or the licensee status, if you're on a property without the owner's permission, which in this case was true, the owner being the owner of the apartment complex. Now, it is true that there is that as it pertains to social guests, the plaintiff has stated the correct rule of law that a social guest is considered to be subject to the invitee status or duties with regard to a landlord. However, this case is really different from some of those cases where they typically allow that level of duty with regard to social guests. This is not a one-off or even a two-off situation where someone is simply inviting a boyfriend or a girlfriend or somebody else onto the property. This is a situation where the plaintiff was actually living at the property, and the whole reason for a lease is subject people living on the property to the same rules and regulations that an actual tenant would have on the property. Essentially, simply converting the plaintiff to a guest when she's actually residing on the property without a lease would not be consistent with public policy, because it would essentially allow someone who's living in an apartment to skirt the rules and regulations that are required by the landlord, but then require the landlord to provide the same duties that it would to someone who actually was a tenant. So for those reasons, the status here is not that of a licensee, but would be more consistent with that of a trespasser, because she's living there without the permission or consent of the owner. And when it comes to trespasser liability, the owner only has the duty to refrain from willful and malicious conduct, which is tantamount to intent to harm. And that clearly has not been alleged, and nor has it been proven. The other issue is whether the plaintiff satisfied in providing notice of the problems at issue here. While the plaintiff has submitted subjective testimony claiming that she repeatedly told the landlord about these bats, there's been only one document produced, which was an email to the defendant, which was returned undeliverable. The defendant does not have any documentation showing or establishing an email. The plaintiff has not produced a document showing that it was delivered, although they claim that it was in fact delivered and that there was a response. However, no documentation to that effect was produced in response to the motion. The final issue really concerns a lack of proof regarding causation and damages. And I think this is one of the bigger components, at least as it pertains to the daughter, because there is absolutely no evidence that she sustained any bite in this incident. And the plaintiff hasn't produced any medical records of her at all. There is no medical records that have been produced that establish that she suffered any injury with regard to the bats. Plaintiff merely says that she has a fear of bats and flying things, including butterflies. However, that's strictly the plaintiff's subjective testimony, and there, without any records actually corroborating that, there is no basis for a fact finder to actually conclude that medically she suffered any type of injury as a result of this incident. With regard to Karina, at most, there is evidence that she sustained a minor bite mark on her hand. So if that creates an issue of fact, then obviously that would be an issue of fact regarding that specific issue. However, the contention that she suffered rabies or other sequelae from this bite mark, there is no basis in the record for that at all. The plaintiff has not produced any medical doctors to substantiate that. Defendant has an expert indicating that there has been no sequelae or subsequent injury from that bite mark. The plaintiff has cited one case that says that expert testimony is not required if a injury is within the common knowledge of the plaintiff. However, that case has been substantially limited, and in fact, the Howard versus Feld case states that expert testimony is required to establish causation. And I believe the main quote is where a contested issue involves medical questions beyond the scope of lay knowledge, such as the existence or not of an injury, or the scope of the injury, or the causal link, then lay testimony regarding that is improper. And I think that's well understood as well, that the only reason that in the Gibson case, I think it was, the plaintiff was even allowed to render that testimony was because I believe the collarbone fracture was visible, essentially. So if you want to use that same logic, okay, the bite mark was visible, but any actual evidence of a causal component of any sequela from a bite mark has not been established and requires expert testimony. And the plaintiff has simply not produced any expert testimony establishing a causal nexus between her ongoing complaints and the bite mark that she had. So for those reasons, the defendant respectfully requests that this court grant summary disposition, and I will entertain any questions that the court has.
I may have some of them here from plaintiff.
Okay, thanks.
Yes, thank you, Your Honor. I'll just respond to the 3 points in order that defense counsel presented them. As far as the plaintiff's status on the land, I went through defense counsel's brief as far as trying to find anything that talks about the amount of time a social guest has to spend at an apartment before they become what defense is claiming here to be basically a de facto tenant. I didn't see anything, and I don't see anything in the case law either to that point. I believe the case law I cite in regards to a social guest being a invitee of the tenant still holds here. Further, if they want to argue that, one of the arguments that was made was that, well, she's benefiting from being a tenant and not having to either pay rent or be subject to the rules of the landlord. But to that end, and I know defense said, well, you didn't submit any documentary evidence in this case. We do have the email to Robin Yob at superiormanagementsystems.com. And you can see clearly that the first email that she sent, and this is plaintiff's exhibit 2, it was just a simple typographical error. It said .com and it came back undeliverable. And then she forwarded it to the correct email address to Robin at superiormgmtsys.com, received a response from Robin Yob. So, realistically, it's more on the landlord to have someone who they know is living on their property and then not try, I guess, enter into a landlord-tenant scenario or to take any actions to, evict or move that person out. But again, I think that's getting too far into the weeds. As far as status goes, she's not a trespasser. Certainly the landlord knows she's there. She's a guest of her aunt and her mother, which means that she is an invitee to the landlord. The landlord benefits from their tenants being able to have guests over. That's the pecuniary interest that they have, and in this case, that's what they received by, having a situation where Miss Dawson Brody and her daughter felt comfortable staying with their mother and their aunt at that property. So as far as status goes, I believe that they should be deemed invitees, and then if that's the case, we just go on to the next argument, which as far as notice goes. This is a motion for summary disposition. There shouldn't be, questions of credibility at this point. We do have the, although not necessarily disinterested because it is the aunt, but the aunt Michelle Dawson was deposed. She testified that she had seen bats as early as 2021. She'd seen bats in Miss Dawson Brody's apartment prior to the incident. And although she didn't claim to report it, Miss Dawson Brody's mother, Marla, was deposed and verified that not only were there bats in her apartment, there were bats in the complex across the street, which was also owned by defendant. They were experiencing issues with bats in the hallways and residents having to chase them out. She confirmed the incident in August that we talk about in our brief here, where there was a first bat incident and the bat was taken into the hallway and killed. And she also testified that she complained several times to Robin Yob, one of defendant's managers, as well as the maintenance staff about the bat issue. And this is all before the September 2nd bat incident. So as far as whether there is notice, I believe there is a question of fact. Again, the emails and phone calls are attached. I would put to the court, I know defense says, well, this is pretty, weak evidence and it's something that she just put together. In order for that to track, my client would have had to have known her and her daughter were going to be attacked by a bat on September 2nd, because all these predate that. We do have a solid date for the date of the incident because that's the date they went to the emergency room and said we were attacked by a bat earlier. So we do know the date and we do know that these records pre-exist that. So there is a question of fact whether the defendant had notice. As far as damages go, I don't disagree that my client cannot testify that she has rabies, nor is she going to testify that she has rabies. The whole situation here is the fact that she was afraid for a time that she was going to have rabies. She was bit by a bat. Her damages being bit by a bat, I don't think are able to be disputed. Likewise, her daughter's damages, although not physical, I mean, you have testimony of the mother saying that even leading up to this, she had to sleep with the lights on in her apartment. She was afraid of the bats at that time. Following the actual incident with the bats, she stayed at her aunt's apartment as opposed to her grandma's because that one had less issues with bats. She has fear of bats and small flying animals now. These are all things that started on this day. You don't need an expert to talk about your own personal traumas that you've experienced. I would agree that there's not a physical injury, but there's no requirement under a negligence case to even have a physical injury. You can certainly just have emotional damages associated with an incident and with the negligence of defendant. So for those reasons, I think there's a question of fact as far as notice and causation and damages. And that as well, I think as a matter of law, this court can rule that the plaintiffs were invitees to the defendant in this case.
Well, sir, I understand the mother was bit, but the child was not, correct?
Correct.
And the mother did not have rabies, but had to go through the shots because of the nature of bats, correct?
Correct.
And the daughter never went through a series of shots. She was 2 years old. I don't know how much she remembers or even knew. I also don't know if there's some kind of association with her mother's fear going on to her. Are there any experts for or against that?
No. The only expert you're on, oh, sorry, go ahead. I apologize.
That's okay, go ahead.
I was going to say the only expert is the one that defense retained specifically regarding the rabies and the fact that who one confirms that Miss Dawson Brody was bit by a bat, but two says that at this point he can say she does not have rabies. She would have had symptoms associated with that at this point. So that's really the extent of his expertise, is that Miss Dawson Brody does not have rabies, which we don't dispute.
Okay, so there's no dispute that neither one has rabies. It appears that neither one has sought or received any psychological counseling. If it's so bad, if the trauma is so bad, am I gonna hear about trauma counseling, therapy, any of that?
No, Your Honor, not as far as treatment goes.
So what are your damages based on? Because I can tell you, I've been in a lot of friends' homes in Michigan who have bats, and they get bat removers and whatever. Do I like bats? No, they give me the willies. I mean, they creep me out too. I think most people respond like that. So what beyond not liking bats, which I guess is the reaction of most people, what are the damages that we're going to court for?
Yeah, so
You've asked for $1 million.
Well, I think, to be fair, Your Honor, we have never actually demanded $1 million. That's that fun question that defense attorneys like to ask during depositions. What do you think your case is worth? So that's my client testifying as far as that goes. But as far as the elements of damages go,
Let me stop you there. The
Sure.
threshold here in this court is 25,000. I don't even see how it rises to 25,000.
well, yeah, sure, Your Honor. Well, I mean, as far as the amount of damages go, that's certainly going to be up to a jury. We are going to claim all of the elements that we can claim for emotional distress, for loss of pleasure and enjoyment, all of those elements. And if living in a bat-infested apartment, having to live with the lights on, fearing of, bats and small creatures, if a jury says we don't think that's worth much, they say that. But as far as to say as a matter of law, there are no damages here. Again, whatever a jury decides the emotional impact is of this, and it's not just living with bats. It's an incident where, take the daughter, for example, she's laying asleep in the apartment. Her mother wakes up being attacked by a bat. The bat bites her mother. That is not like an insignificant trauma, I wouldn't say. But it would be up to a jury to decide what that is worth. So I guess that's what I'd say.
Sure. What are your damages based on? I mean, a jury has to have them. You're going to be arguing here as to the value. Understanding a jury is going to decide. They can decide that in district court. I'm not sure it rises to the level of what this court does.
Yeah,
Does it?
Again, I would argue that I don't think non-economic damages, there's a way to say what its absolute value is. I mean, they're all non-economic damages. I can't plug it into a calculator, Judge, and tell you here's what each one is worth. That's going to be the jury to decide as far as the damages go. I can't.
Do you have an expert relating this child's fear directly to that incident when she was 2 years old? We do need some experts to link the dots together, don't we?
I mean, we have the testimony of Karina and her daughter who would testify at trial about how this affected them. You don't need an expert to say, I had a bat attack me and now I'm afraid of bats. You don't need an expert to say, yeah, that's right, that bat fear comes from that attack. Certainly they're allowed to, and that's why I cite to the case I do. That's not something that requires an expert to say that because of this, you have this fear. I don't even think there's a expert who could, unless they're going to be making an official diagnosis as far as, like, say, PTSD or something like that, but that's not something that we'd be claiming. We'd be claiming the emotional impact that this has had on them. And again, the daughter wasn't deposed in this case, which I understand, but she certainly talks about this event and can describe this event, and maybe that is some because of her mother having talked about it as well with her, subsequent to when this occurred. But the daughter's almost 6 years old now. She's not a toddler or anything who would be unable to talk about these things.
How long did she stay in this bat-infested apartment after she was bit?
I believe this happened, give me 1 second, Judge. I actually have the date. Give me just a moment. I believe it was November, but I have it. I apologize, Your Honor. I just don't know the answer off the top of my head, but I do have how long they stayed.
Okay, I've got attached, I believe it was to defense, it's medical record. And it's from June 17th, 2025. And it's from a doctor who is a board certified infectious disease and practices in southeastern Michigan. They reviewed the paperwork. And it indicates in here that the patient is a 27-year-old female with a past medical history of hypertension, presents to the emergency department for rabies vaccination. Patient had exposure to a bat a couple weeks ago in which she was bit by a bat on the right thigh. She got initial rabies vaccine 2 weeks ago, but missed subsequent doses after that because her child was sick. She is now here for her second dose in the series. She had gone to the infusion center, but they did not take her insurance, so she came to the emergency department here. She denies any symptoms. The bite mark was to the right thigh, has been healing well with no swelling, warmth, or discharge. Medical decision-making was as follows. Patient here for second rabies vaccine. After she was bit by a bat 2 weeks ago, she got the first vaccine and then missed the subsequent 2 doses and is here 2 weeks later for dose 2. The area of the bat bite looks good or looks fine with no evidence of local infection. Patient denies any symptoms. We'll give rabies vaccine today, and then I recommend the patient get back on schedule to get dose 3 in 4 days and then dose 4 in 11 days. We'll discharge home. Update. I was notified by the nurse that patient eloped from the emergency department prior to getting her vaccine. Patient got up with daughter and left the emergency room. That was at 12:08, and the nurse documented. This is dismissed in full against both. She didn't care enough to get the shot. She didn't follow through. I don't care enough to follow through. You want to refile this, do it in district court. I am dismissing this with prejudice against both. Thank you.
Wait a minute, Your Honor. Sorry, I apologize. Just as far as you're saying there's no damages that rise to the level of the circuit court to refile in district court, but are you then dismissing it with prejudice?
You decide if you want to file in district court, but absent any more information, I'm dismissing this with prejudice because I don't see any basis here. The mother did not care enough to follow through with her own care. I don't know anything about the psychological status of this child. A 2-year-old maybe barely remembers it, but when coached by a parent, I guess we have a battle of the experts of whether or not she remembers it on her own or she's seeing mom distraught. I don't know what's going on here, but basically duty, breach, causation, injury, I don't see the connection on all 4 of those elements, which you must prove. And I also do not think that you meet, if you can prove that, I do not believe that you meet the threshold for circuit court. So I'm dismissing this with prejudice. I don't usually do that, but this case looks like someone wants a windfall to me. I guess the appellate court's the next stop, or district court, or you can file a motion for reconsideration, but do it timely. We just received your brief, your brief now, and you know, it wasn't timely. I read it anyways because that's the kind of judge I am, and I know how busy practitioners are. I was a busy practitioner, but sir, this case should not be before this court. It is dismissed with prejudice. You'll prepare the order, sir.
Yes, I will.
Thank you. That's all for the record.
Okay, thank you, Judge.
Thank you.
Oh, this is that.
All right, this is docket 25-5771 CH in Ray petition of Ingham County Land Bank, Fast Track Authority for expedited quiet title and foreclosure of certain parcels of real property. Counsel, your appearance, welcome back.
Good afternoon, Your Honor. Timothy Perone appearing on behalf of the petitioner, Ingham County Land Bank Fast Track Authority.
Thank you. And I don't see anybody else here. You sent out the proper notices and publications, and so I don't see any reason to not grant you what you wish.
Yes, Your Honor, thank you.
Thank you. Do you have an order?
Yes, I do, Your
You may
Honor.
approach.
Approach.
How many copies do you want? How many copies would you like?
3, please.
Okay.
All right, anything else for the record, sir? We'll get your copies to you.
No, Your Honor, thank you.
Thank you, that's all for the record.
The next one was at 2:32. All right, let's see what we can put. Or maybe further if you don't know. Let's just put it here. This is at 2:30. For the next one.
Actually, I need one of them certified. I can go to the clerk and get.
Yeah, you don't have to go down the quick.
Yeah, but we'll get you the copies so they don't charge you for that too.
Maybe get the staple out.
Did you got like a million staple colors?
No, I put them in the back because they can be dangerous.
Which, in your drawer.
They're dangerous for me. But we should be good on that one. I don't know if everybody's here or not, so it's at 2:30, so.
Brian, we need a stapler.
Nope, I got it. Thank you, Beth.
Is anyone here on the most matter?
Yes, I am. Your Honor. I don't.
I'm here on Zoom, Your Honor.
All right, thank you. This is docket 23-57 and H. Rex Most and Jackie Most versus Edward Sparrow Hospital Association, doing business as Sparrow Hospital, Sparrow Health System, and Philip Quintella, CRNA, jointly and severally. Counsel, your appearances for the record.
Good afternoon, Todd Schrader for plaintiff.
Thank you, Your Honor. Jasmine Merchants appearing on behalf of the defendants in this case.
Thank you.
Counsel Geiger. Yes, 85361. Thanks.
And this is defendant's motion to strike any and all lay and expert witnesses?
Correct, Your Honor. So there's been about 5 adjournments of discovery in this matter. Trial is currently set for January. I want to start with just addressing what plaintiff replied in his response, that we haven't made any requests to depose witnesses other than a blanket request for all witnesses to be presented at trial. I believe that's 1, contradictory, and 2, if you look at Exhibit B to our motion, you can see that there have been numerous requests to depose all of plaintiff's lay and expert witnesses that they intend to call at trial. The entire point of the pretrial discovery process is so that we have the opportunity to know what these witnesses are going to say at trial, so we can evaluate these claims, so we can report them to our client. And there's established case law that this is the entire purpose of the pretrial discovery, is to narrow the issues, prepare for cross-examination, and eliminate surprise at trial. Plaintiff simply states in their response that they don't know which witnesses they are going to call, and that they should have the right to subpoena any witness on previous witness lists, but that does not help expedite the judicial process at all. We don't know who they're going to call, as there's numerous witnesses on each witness list. And certainly in these medical malpractice cases, we need the opportunity to raise any Daubert challenges to any opinions of any potential treaters. So at this point, we have agreed to adjourn discovery over and over again. We even offered to take the deposition of one of their witnesses outside of the close of the discovery, the dispositive motion deadline has passed. So at this point, we just want to, if this matter is preparing for trial, just know what our proofs are so we can adequately prepare for trial and report that to our clients.
Thank you. Counsel response?
Thank you, Your Honor. In my response, you'll see that I agree to the striking of plaintiff experts not produced for deposition. So plaintiff has agreed to strike those experts, Dr. Moylan, Dr. Seawick, and Dr. Brasio. As to family member and friends, it is correct. I haven't made trial decisions about if any family or friends I would present for testimony at trial, but they were identified for the defense in a witness list dated January 10th, 2024. And even though discovery is closed, if they want to request specific individuals for deposition, then we'll gladly produce them. I do not interpret the defense motion to strike as applying to subtreaters. Those are not witnesses that I have control over, that the defense has control over. And in my experience over the years, if a party ever wants a subsequent treater to testify, that person is subpoenaed for deposition. So they've always had the ability to subpoena any treaters they want to subpoena.
So how many witnesses are on your list?
Well, let me pull that up one moment, Your Honor. There might be, I'm thinking about 6 family members or friends.
You have about 6 witnesses? Is that it with lay and?
Of family members or friends, in terms of lay witnesses.
Okay, lay witnesses 6. How many experts do you have?
One moment, Your Honor. I'm sorry, I don't have that pulled up right in front of me. All of my experts have been deposed that I would be producing at trial.
Your Honor, if I can respond.
Just a moment. So every expert that you've named has been deposed?
Yes, every plaintiff retained expert has been deposed that I would produce at trial. That's correct. And those experts on my list that have not been produced at deposition, those experts I'm agreeing to strike, as indicated in my response.
Okay. So now, on behalf of defendant, he's agreed to strike a couple of different experts. And is it true that all of his experts have been deposed now?
That's my first understanding of it. And the issue in these cases is these subsequent treaters, they end up getting sworn in as experts. So if plaintiff plans on calling a subsequent treater as a witness in their case in chief, we should have the opportunity to cross-examine them at deposition. So we've been requesting, and this is why we specifically say all lay and expert witnesses, because those subsequent treaters fall in this blended category where they are a lay witness, but they're also an expert witness at the same time. And so we should have the opportunity to depose these potential subsequent treaters prior to trial. If not, this is purely going to be a surprise.
So, okay, so the issue isn't the expert. The issue is the subsequent treaters. Sir, are you calling any subsequent treaters?
I may call one. I haven't fully decided yet, but no subsequent treater, from my perspective, can ever give standard of care testimony, nor causation testimony. They're simply fact witnesses as to treatment that's occurred. And I may call a counselor, for example, as a fact witness as to treatment that has occurred. But not, again, no subsequent treater, from my perspective, could or should provide standard of care or causation testimony.
So your subsequent treaters would be fact witnesses. Have you identified those for defense?
Yes, they're all identified within the witness list.
So how many subsequent treaters have been identified? Because you've told me all the experts were deposed and there's about 6 family and other witnesses. So we haven't yet identified how many subsequent treaters. Do you have an approximate?
Well, there are many that are identified within the witness list, really about every name from the medical record. I don't think I would call more than 2 at trial.
Well, the thing is, if you're going to call them, they have to have the opportunity to prepare their defense and to depose. So there's a cutoff for naming these people, unless you want them to name all of them, the price goes up, and then at the end of the case, we figure out the cost, and it could be astronomical.
The cost to depose these various peoples?
Well, sir, there's a court rule that talks about who wins and who loses and who's responsible for paying costs and all that other stuff. And so I think both of you have an obligation to keep each other informed of witnesses for trial preparation, but also to keep costs reasonable because someone's going to get stuck with it. And I think what they're asking for is reasonable so we can get to trial. Otherwise, do you want them to depose every subsequent treater that you have and I delay this out another month or two?
Well, no, I'm happy to provide a formal trial witness list if that's
Great, that's what I want.
Okay.
When can that?
How about by Friday, Your Honor? And I would note their witness list mimics my witness list in terms of identifying subtreaters and so forth. But yes, I'll file a notice on Friday.
Your Honor, I don't think that solves the issue though, in the sense that if he just intends to file his already previously listed witness list with multiple subsequent treaters, and then we also don't have dates for these people's deposition prior to trial. So I think the purpose of this motion is so we can properly evaluate these claims prior to going to trial. So I can report to my client, to my carrier, the damages that this potential treater will assign this case, what they're going to talk about in terms of maybe emotional damages, assuming he's going to call a psychologist. That very much affects the damages and like my duty to my client. So I think him filing a trial witness list, if he's going to not also provide discovery dates for these witnesses too, or deposition dates.
I don't think, counsel, it was not your intention to refile what you've already filed. It's your intention to file those people who you will call.
Exactly, Your Honor.
Okay, so it's going to be a limited list, which is what you're asking for. And then are you deposing any of them? Otherwise, the other side can certainly call and depose them as well.
No, I'm not going to depose them, Your Honor. They're subtreaters. I don't know their schedules. They don't even have an obligation to speak to me. And so in my experience, if anyone wants to depose a subtreater, they do so by way of a subpoena to that individual. I don't have control over those witnesses.
Great. You can subpoena them.
Well, if he's going to subpoena them for trial.
But just two different things. You want to subpoena them allegedly for deposition to see what facts they're going to testify to, and you certainly can choose to do that.
Are you referring to the defense, Your Honor? I think the defense would want to subpoena them, or would want to depose them. I would subpoena them for trial. I think the defense is asking to subpoena them for deposition.
You subpoena them for trial.
Yes.
Whoever wants to depose them gets to subpoena them for deposition.
Agreed. Yes, thank you.
Now, all of this is going to be done. You're going to give the list by Friday. We have a trial date, what, January?
End of January, correct.
If you cannot get all the depositions done by then and prepare, then I need you to call my office and get a date that's a month or two out there. Not that I want to move this, but it seems like there's no other choice. Meanwhile, we're going to keep the date. I suspect these depositions are going to be rather short.
I agree.
So maybe they're done before trial, and if you need to move it, get me on the phone or just talk to my judicial assistant or my law clerk. We'll move it a month or two. If you need my intervention, please contact me.
Thank you, Your Honor.
Sir, make sure your list is reasonable. Don't bring me back here because I might not be so kind, okay?
It will be, Your Honor. I agree.
Thank you. That's
Thank
all
you.
for the record.
And,